Greetings, everyone. Good morning or good afternoon, depending on where you're joining us from. I'm David Singleton, and I'm a professor of law and the Dean for Experiential and Clinical Programs at the University of the District of Columbia, David A. Clark School of Law. I'm really honored and excited to start off the second episode of our sixth season of Conversations with Clinicians. For those of you who were unable to join us for our previous episode this season, we brought together immigration clinicians from Mexico and Italy to share their practices and ideas. And you can find this episode along with many other conversations that we've had over the years at our YouTube channel, and a link is provided in the chat. So Conversations with Clinicians features UDC School of Law clinicians in discussion with leaders in the experiential education field. As early leaders in clinical legal education and at a school where all of our students have to take between 10 and 14 mandatory clinic credits as a graduation requirement, we developed this series to create a space where clinicians across the country and, in this season, the world, can engage in topics of interest while exploring some of the most pressing issues facing our community. We will start this session with cameras off until we reach our question and answer portion, where we'll welcome you to join us on screen to add your questions to the chat. So let me get to it. Today, I'm thrilled to introduce Professor Emily Casamadas, who directs UDC's legislation clinic, and she'll be in conversation with Professor Federico Isaza, director of the Action Program for Equality and Social Inclusion Clinic at the University of Los Andes, and Professor Renata Bigaggio, director of the Legal Clinic on Disability and Human Rights at the Pontifical Catholic University of Peru. Together, they'll be exploring legislation clinics, disability rights, and disability justice. Professor Casamadas?
Thank you, Dean Singleton. Welcome, everybody. We are so glad to have you here today. And we're going to jump right in. So I would first like to invite both of my guests to introduce yourself, briefly describe your clinic structure, and then since we all need wins, especially these days, give us an example of one big win that your clinic has had. Renata, do you want to kick us off?
Yeah, thank you, Emily. Thank you so much for the invitation. I am the professor and the director of the Legal Disability Clinic in the Pontificia Universidad Católica in Peru. Our clinic emerged on 2012, and it was promoted by a project of Open Society Foundation. They wanted to implement disability clinics in several countries of Latin America. And since then, we have been working in, I would say, four big areas. We have the litigation area. We also have an area that prepare amicus curiae in cases of, in leading cases before the Inter-American System or national courts. We also have an area related to training, and finally, an area dedicated to advocacy for legislation. And under this last area, I will say that even though we have been part of most of the legal processes related to disability in Peru, perhaps the most important achievement for us has been our participation during the whole legal capacity reform process. This process started in 2013. In 2012, Peru passed a new legislation on disability that was quite well aligned to Convention of Persons with Disability. And according to that law, the Congress should create a commission to prepare this draft for modify the civil code and other very important legislation in order to guarantee legal capacity to persons with disabilities. However, nothing happens. So we start talking with civil society, and with the backing of them, we request for a hearing before the Inter-American Commission of Human Rights to push Peruvian government to create this commission and start the process. And it was a very important case and a very important achievement because the Peruvian government arrived to the hearing in Washington with the draft of the resolution that creates the commission. So the next month after the hearing, the reform process started, and of course we participate during the 4 or 5 years that took the negotiation of the reform. And during this period, we were part of the discussions, always working together with the civil society of persons with disabilities.
Thank you so much, Renata. Federico?
Thank you, Emily, and thank you, everyone. Very nice to be here talking this with you and with Renata. Very briefly, well, I'm the director of PAIS, the Program of Social Inclusion and Equality at the University of Los Andes. We was founded in 2007 as one of the public interest law clinics of the Faculty of Law. And we born as one of the actors that promoted the ratification of the United Nations Conventions of Persons with Disabilities, understanding the importance of creating a space from academia to work for the recognition of the human rights of the population. And as Renata, we do also a very profound work in terms of high impact advocacy through cases in different scenarios, through litigation, advocacy, administrative procedures. A very important part of our work also is of social legal research that is ethically committed with the populations that we work with, national and international advocacy for compliance with the international human rights standards, are very committed with legal clinic education and experiential and critical, and also in the context of Latin America with the popular education pedagogy. And we work a lot with an alliance with civil society organizations at national level, a lot of interclinical work and training with our students through workshops, classes, and generation of specific documents. And also as Peru, that's also because we are so friends with Renata and the legal clinic in Peru, is that also we have in 2019 the absolute modification of the legal capacity framework. In PAIS, we begin that work almost 15 years ago with a lot of litigation with cases that eventually turns PAIS into the technical secretary of the table that was involved with entities, international actors, civil society actors, and people with disabilities to present a document that will be the law that changed everything in 2019. So yeah, that will be.
Thank you. And just to give people an idea of what I'm doing here at UDC Law, I took over the legislation clinic this past school year. And the legislation clinic is representing organizations in DC that are working as part of movements to change DC law. And one of the organizations we have been working with this semester, the School Justice Project, represents people with disabilities who are incarcerated in DC and who are still young enough to be eligible for special education services. So we have been working with them to move the LEARNS Act through the DC Council. And the LEARNS Act, when passed, would require mandatory screening for disability services for anyone who's still legally of qualifying age in the DC jail and asks for it. And this would be a huge change in how people with disabilities get access to education services while they're incarcerated. And my students were able to get the bill moved through markup and through first vote. We're just waiting our second vote next month. So we're really excited to see what it looks like to be putting putting those ideas into action and moving from legislation to implementation soon here too. All right, so my next question for both of you is to tell us a little bit more about the role of the student attorneys in your clinic and what you think that they learn specifically at the nexus of legislation and disability policy.
Okay, well, I'll go first. For us, it's very important that our students participate as lawyers in the more integral way. So, for example, if you are talking about litigation, of course, because of our litigation rules, they are not in the possibility to participate in a hearing as lawyer. But in other scenarios, we always try to put our students in the role of the main lawyer or of the principal lawyer of the case. So we try to replicate professional life in the space of our clinic. And because of that, when we are doing legislation work, we always put our students in contact with the civil society of persons with disability, and they are the ones that talk with the organizations, identify the interests, prepare all the papers and the reports and the proposals, and review the proposals and participates in the negotiations meetings. And as a result of this work, I will say that for me, legislation work in clinic generates three different levels of learnings, maybe. I will say that in a first immediate level, and this is very common in clinic education, students learn how to become lawyers, of course. But in the case of legislation work, I think that uh, this is a work that at least coming from my university as a private university is not always shown as a possibility in the professional field of work. So my students don't dream to become legislation lawyers. They dream to become, I don't know, the head of a law firm or a corporation, and maybe working in a civil society organization or probably in a public entity, but no as a person that works in the elaborations of rules and legislation, etc. So I will say that this is a very specific field of work, and legislation working clinics shows them the possibility to see that there are very other another scopes of works that are not so showed in our School of Law. So in a second level, I will say that a clinic in general, and of course legislation clinic too, shows them that law is not always fair. So they learn how to fight against the law in order to combat structural social injustice. And this is a very important learning too, because I think that in order to do that, they also have to accept first that they are part of the system. We are fighting again a capacity system, and I have to accept that I am also part of the system and have to start to deconstruct some categories in order to work with persons with disabilities. And finally, and I think this is a specific learning from the work with persons with disabilities, is that they learn that persons with disabilities are real persons, because there are a lot of myths and stereotypes related to disability, and even or they even believe that persons with disability are always good people, or that persons with disability are not in the possibility to identify why they need or what they want. So the work with these organizations let them know that persons with disabilities are complex individuals as any other, and that conversations, negotiations could be difficult too, because you are not obligated to be nice with the person with disability or to be friend with the person with disability, and the person with disability could be very, very upset and a very upsetting person. And for me, that is a very important learning, because that's the way I think we should learn about diversity, that not create archetypes or stereotypes about how these persons are.
Yeah, well, first, absolutely. Yeah, I think I do a lot of echo on what Renata said. Maybe just to contextualize the practice here in Colombia, very briefly. Here in Colombia, the students carry out a legally mandatory final year practice within something that is called a consultorio jurídico. It's a specific office that faculties of law has and have authorized by the Ministry of Justice that offers legal and free legal representation to low income and vulnerable people. And the students do this in different areas, no? More traditional areas, family, labor, civil and criminal law, and carry out also conciliations. And in addition to these more traditional areas, we have the legal clinics that operate in a very specific context of focus on advocacy at different levels, um, and in more specific problematics and populations within human rights. In this sense, I think that because of the different approaches and activities that we do in our legal clinics, the first thing is that students take direct responsibility for individual cases. In our situation, we have a broader law that is more permissive and have the possibility for students to also represent directly some of the cases. And in that sense, they are in a lot of situations that Renata also told, but also with the judges, with other officials and persons that are involved in the resolution of the cases. And here is very important. One of the things that Renata said about the complexity of working with people. In general, but also with people that have a lot of necessities that are not only the necessities within the justice provided system that for the and the problems in the law that they came initially. These are various situations that are structurally a lot of inequalities, a lot of poverty. So it's also like a form of teaching how is the ethic of every individual and lawyer that is working in these scenarios. And working with these scenarios, I think that also they can develop a community lawyering sensibilities through a lot of the activities that we made in terms of popular education workshops, working alongside people with disabilities and their organizations, rather than speaking on their behalf. That is very important. And also I think that they develop a lot of oral and critical writing skills, because they connected live the disability experience with legal tools and to question traditional hierarchies between the lawyer, the academics, and the community, and what is their role in there. And and I think that the other thing is that they become very prepared to anything with they will be working in the future. We have a lot of ex-students that are working in not only in NGOs but also in the more traditional areas of lawyering. But they have the radar of telling disability critic where those things will happen in the day-to-day work. And also because of the experience of working in important spaces with institutions, with the civil society organizations, participating in the events, and that I think is a very integral and complete set of skills that they develop in the legal clinic aspect.
Thank you. Federico, you talked about really breaking down hierarchies, and Renata about deconstructing the law. And I think that in legislation clinics in particular, it's impossible to teach the creation of the law without teaching about the power that is involved in this process. And so I bring a lot of critical theory into the classroom, critical race theory, crypt theory, and I'm wondering if that's something that you all do as well, and how you teach crit theory to your students and how they use it in their representation. Federica, you want to go first?
Ah, yeah, perfect. Yeah, I think it's it's very important what you said, because students are, I think, encouraged to interrogate the power, as you mentioned, but also the ideological functions of the legal doctrine, than just applying it. So it's absolutely fundamental in teaching, especially disability law, because it shifts the focus from a pure technical formalist application to a, maybe in some cases, a counter-hegemonic analysis of power, of exclusion, and social transformations. And I think that this influence a lot in the ways that the students also um, are interconnected with the cases and the people that they have been working. And in the cases of, I think, I don't know if Renata is also acknowledge this in terms of the importance of the legal reforms of capacity in our countries, because that is a transformation of how we understand everything in terms of the law, uh, and the visibility of how you can, through the law, reinforce structural injustice under the guise of protection, and how within the law you can also reject that and transform it. So in this sense, I think that the other thing is that traditional education, in terms of the legal, often relies on standard or normal conception of the legal subjects, which is implicitly exclude those people whose experience the world very different. And this critic allow us maybe to deconstruct like this false universalism that the law has, and in terms of disability is ableism, is to critique the world in that terms. And the other thing that I think is very important is, and also following a lot of critical race and feminist legal traditions, the thing of looking to the bottom, no, the lived experience and testimonies of people with disabilities, and those who have felt the false promises even of the law that we are entitled to protect, become the primary source of knowledge within the cases, within the advocacy, within the legal strategies that we make, and also the possibility of change. I think that, just to finish, I think that they also within this uh, learn to identify the biases in the legal system, recognize the political dimensions of legal rules, and even the decisions that the judges made, and how they view themselves as agents of social change, who have also a moral duty to help the persons that are in contact with them.
Yes. Well, I totally agree with Federico. I think that um, critical legal theory, it's a tool that is unavoidable in learning in clinic spaces. As I mentioned before, we are not, when we do clinic education, we are not fighting against a person that broke the law. We're fighting against a system that perpetrates these violations. And I always said my students, choose any area of the law and introduce a person with disability in it, and you will find at least one problem that the law didn't anticipate. And for me, the key issue is to ask the question of who are beneficiate because of the law. So in classes and in the clinic spaces, we discuss and we reflect a lot about who are beneficiated by this law. For example, here in Peru, we have this alimony system for adults with disability. And it seems like very reasonable because, of course, the cost of life of a person with disability are higher than of a person without disability. But the law states also that if you get this alimony from your parents, if you are a person with disability as an adult, you are not in the possibility to work anymore. So the state puts you the label of incapacity to work. And so you will get your alimony, but you are not in the possibility to work. So for us, the question is, okay, who is beneficiated by this regulation? Is a person with disability? It could be, because you will say, oh, but the person will get some money. But at the end, I will say that the main interest is putting in avoid person with and to sorry, the main objective is not to allow persons with disability to be part of labor market, because if they want to work with us, I should prepare my environmental work, I should train my employees, I should like change completely my framework of labor law in order to allow persons with disability to be part of the workforce. So I think that the main issue is always to ask who is the person that is going to be beneficiated by that, because um, law always tend to do that, to create the false expectation that women are going to beneficiate because 3 months license after having birth, the idea that persons with disability will be beneficiated because they will get some money. But at the end, that is not what happened. At the end, the systems try to maintain an status quo, but hiding these persons, or trying to this person don't get a plenty inclusion in our society.
Mhm, mhm. The disability rights movement is the movement that popularized the phrase "nothing about us without us" in English, in the United States at least. And I'm wondering how you use that as a framework for your clinic. How do you use the leadership and follow the leadership of people with disabilities when making decisions about the policy priorities to pursue?
Well, yes, for us, the that statement is very present in our work. Um, well, we just said a minute before that a legal profession can be very hierarchical, and of course it is, because we always lawyers are seen as the wise. And if you are also dealing with civil society, not a rich client, but civil society, of course, this is it's very tentative to be, okay, I am the person that knows everything, you don't know nothing, and I will teach you and I will let you know how to proceed. So for us, it's very clear that if we are working on disability rights, and we are working to promote disability rights, agency, and autonomy, we should start from the inside. So that became that we don't act without the backup of persons with disability society. And even in this scenario, sometimes it's very it's some difficult, because at least in Peru, we don't have a lot of civil society of persons with disability. We have a lot of civil society of organizations of relatives of persons with disability, and sometimes they are not in the same page. Sometimes when it becomes from autonomy, especially, the relatives of persons with disability don't want so much autonomy for their sons or daughters, but persons with disability wanted autonomy. So we are always very we are always trying to not to act without the backup of the organization of persons with disability itself. Uh, we are not an organization of persons with disability. I am not a person with disability. So for us, it is important to keep in mind that they are the main actors of the process. And part of the process is not always the achievement of the process, or the goal is not always to get a legislation, because sometimes that wouldn't happen. I will say that it is important to depart from the idea that the main goal of the process is the process itself, because during this process, you will empower persons with disabilities to be aware of their rights, to learn some strategies to present their interests and say what they want. And of course, they will learn how to present a formal proposal and how to talk with, I don't know, with congressman and everything like that. But the process itself is very valuable. So it is important to take care of the process.
Thank you.
Yeah, I completely agree with Renata. Also that a motive and legend of the convention is absolutely primordial here in Colombia. It's a very um, it's the north for everyone who works also in disability here, and in terms of our work, I think would be in two levels. First, at as internal policies mandates in terms of the representation and work with the cases and people with disabilities, is that the direct user is always the person with disabilities, whether if they are supported or not by their families, or they need support for communications, or to make decisions. But in terms of guaranteeing that consultations, that decisions around the cases are guided by the will and preference of the person with disabilities. That is our most important internal policy, and that affects also all the process that Renata was telling about, that is very important, and it also relates a lot with um, the formation and the skills that the students also have to work, because they have to know when the third ones are supporting, or maybe are trying also to present their interests in order to make changes in the legal strategy. So they have to be very aware of that, and at a more digamos, advocacy level, our policy work is also channeled through a lot of strategic alliances with organizations that are led by representing people with disabilities, or persons that are working around people with disabilities that have also um, decisions possibility in different levels. So in that terms, also, if the demands of the persons with disability communities often, for example, requires to move beyond courts to engage in a more advocacy level at the support of drafting projects, we try to collaborate within the communities and organizations discussions, just as Renata said, not to have a voice, a determinant voice, but to serve more as a bridge between the judicial legal work and knowledge with the necessities that are specific for the persons. And I would like to just to finish with an example that I think has been very powerful for our work, is the Colombian Coalition for the CRPD. That is a human rights platform that was conformed in 2014 to make the alternative report the first exam of the CRPD Committee of United Nations. And with that work, that platform is still working, and it served as a collective scenario of discussions of people with disabilities, organizations, academia, from a lot of places in Colombia. We have 23 organizations in different regions of Colombia that work primarily to have advocacy to the United Nation systems in terms of the shadow reports, not only in the CRPD committee, but also in different scenarios, but also that for PAIS, it makes us like to keep our feet on the ground, is that we obey a little bit of what are the things that are interested by the communities, even though we maybe something that maybe is more urgent. This, they are the ones that are defining the agenda in terms of a consensus that also can be very in contradiction with another interests of another platforms and organizations. But I think that the most important thing is to have for us the legal and human rights standards and the voice of the persons with disabilities, with all, of course, the contradictions and difficulties and tensions that arise in every human rights civil society organizations. So yeah, I think.
Thank you. I think having this theoretical and political framework is so important. And I want people to be able to walk out of this conversation saying like, oh, I learned something that I can use in my clinic in the fall when we get started again. And so I'm hoping that you can talk, both of you have spoken about working in coalition, and legislation clinics in particular have a very early decision point about whether to participate as members of a coalition or to represent the coalition as the attorney. And I'm wondering what kind of factors you all use and take into account when making that decision for your clinics.
Okay. Well, we have as a platform similar to the one that Federico mentioned. It is like a coalition of organizations that works on disability in Peru. I will say specifically Lima, because that's another problem in our country, that Lima is like the center of everything. And we have this coalition. Um, and we started when the coalition was created in 2012. I think 2012. We were part of the coalition. We were a regular member of the coalition. And we, at that moment, we just started to work on disability. We had the new legislation. We didn't have yet the civil code legal reform. But during the years, we starting to notice that that was not our rule. Uh, and I think that at some point we always knew that, because when we were in the discussions, we never had a very strong opinion about how the coalition should proceed. We always moderate the positions, or we always answer some legal questions because we had this technical knowledge. So after like 6 or 7 years, we decided to change our status, and it was a problem because there was no like an advisor organization figure in the statute of the coalition, and we say, okay, let's create it, because we don't want to be a regular member of this coalition, because that's not our role. So it was difficult at the beginning, and I think that it's important to highlight that, because the organizations didn't want us to change the status. They say, no, you have to be part of the coalition. And it was not a fight, but a misunderstanding, a friendly discussion about why that was not our role. And nowadays we are legal advisors. So when we are not in all the meetings, we participate when they call us, or we prepare documents that they need, and we review the documents that they want, but we are not proposing ideas, and we are not driving the process. And I think that is important, because as I said before, it is very easy to be seen as a wise person when you are talking, when you're a lawyer and you are dealing with civil society organizations. And I think there is a huge risk, because you could be wrong about your positions. Because in my case, as I mentioned before, I am not a person with disability. So I can have an idea of what could be good or appropriate for a disability legislation, but I am not 100% sure, because that is not my experience. So I think it's very important to be cautious, to avoid these scenarios when you are put in the in the role to have to decide and to say how to do things, because not only because it goes against the recognition of autonomy, but also because you could be wrong. And it's very different to be wrong if this is your experience and your life, and you made a mistake, or you had a wrong decision at that moment, that if you are giving warranties to other persons that this decision will improve their life, at the end you had a mistake. So yes, for us it was a very important moment in our institutional life, and we decided to not be formal part of any kind of platform.
Yeah, I think that in our case, the first thing Well, I think that I don't know if the rest of the people here in the Zoom will agree or not. But these things I think that are also a reflection of our political decisions as individuals in terms of our role and our beliefs in human rights standards. So I think that that also influence a lot the way that a clinic in a determined point will act. In our case, I think that the degree, one of the important things has been the degree of alignment with the clinic long-term structural goals is weighted. Um, for example, as Renata said, for example, the membership is preferred when the coalition aims matches País institutional commitment to the change, or for example, the international standards. For example, we never will be in a coalition that says people with disability does not have the right to make their own choices. That is absolutely out of the question for us because we are committed also with the voice that the persons with disability put as a critique of the law, and we are committed with that. The other thing I think that is also important and is one of the also a thing that a very good Peruvian friend uh, called Renato says a lot of in terms of the risk of client interest conflicts also. If the clinic simultaneously takes, for example, a public position in terms with a coalition that our university maybe it's not with that scenario because of the political situation in the moment. So I think that is most of a day thing that everyone will have to evaluate, but I think it's important. And also the other two things that I think it's important is that the first one is if that coalition or scenario platform also produces a value of professional education for our students. If the coalition maybe it's just as a scenario where they expect a, a technical voice to do some things, but not the involvement of the students. For example, that is a thing that we try to avoid because we think it's the important thing is that our students can have a voice, can have this advisory role because it also helps them to build critical skills in collective advocacy. That it's one of the things that most of the difficult things that we have. And just to finish, I think also the necessity of some principles in terms of to avoid the risk of speaking for. That is one of our things. The transparency also that we have to have with the coalition and the persons that are involved in those coalitions, and the horizontal relationships. We think that that is a very important thing because to respect the rights of those they represent, the things of horizontal rather than the vertical relationships are very important to us to also avoid this vertical hierarchy that Renata told about the expert versus the lay person. Because otherwise, if we do not have that horizontal things, it's very difficult that the product of the work of that community is going to be very affected later, even with internal conflicts, and that is a risk. But it has to be defined also for us to be involved in that spaces.
Yeah, I think it is so important in both legislation work and movement work more broadly that you build trust with partners. I work with some organizers who like to say that the work can only move at the speed of trust, and I think in this particular type of lawyering trust really does set the pace. It sets how quickly you can get buy-in into goals, how quickly you get or thoroughly you get feedback on something that you've drafted. And I'm wondering how you explain this to students and manage their expectations, maybe their frustrations of the speed at which legislative and movement work moves, as opposed to litigation or something else they might be more familiar with.
Do you want to go first or I go first?
No, go first. Go first,
Okay.
right?
Well, I will start with what you said about building trust. I think that it's very important, and I think that it's a challenge for legal clinics because, of course, the persons always want the lawyer. So if you're bringing students, the person sees you like, I'm not sure. So for us, it's a very permanent rule in our work and for our students is that remember you are a student, but not in the way that you are not capable, but in the way that unfortunately, because you are still a student, you have to try harder in order to build that confidence with the client or with the organizations. And that requires you that you have to prepare yourself in an excellent way in order to go to the meetings, because I don't know, for me as a lawyer, if I at some point I don't know anything, I have the confidence to say I'm not sure, I will check it. But if I am a student, that's the end for me, because the person will never trust again anymore in the student. So I would say that this is a very very important statement in our clinic. And in relation with what you ask, yes, I think that deal with expectations is also a challenge, not only in legislation, but also in litigation, because when you're doing litigation, at some point the client can call you and says, you know what, I don't want to go with this any further, so I just will drop the case. And the students are like, "Oh, but we were supposed to win. How is that now I am not in the possibility to win the case and to have my first case?" So I will say that expectations is part of legal education always. And for us, well, one of the things that we talk with the students all the day, all the time, is that it is important that you have to acknowledge that this could be your work, but this is not your life. And even though I love my job, and I will say that I am a lawyer that mixes quite well life and work all the time, I have to accept that I am not a person with disability and I am not dealing with an improvement of my rights all the time. So it is important that what do you want with your legal work? Okay, you could have some altruistic reasons and you want a better world. Okay, you also could have like very selfish reasons, and I think it's important to talk about that in class also. And sometimes when a cases fail, or the client dropped the case, or the advocacy process didn't turn well, we dedicate very important moments of the class in order to talk about how this process make you feel, because it is important to identify the feeling. And I think that for at least for my students, it's very difficult to identify the feeling. And when they finally did it, they don't want to say, because they feel bad to say, I want fame. I wanted fame. I wanted to be part of this very important case. And it's very honest to say that loud and to talk about what generates that. Because if you hide that, probably it won't disappear, and you will not in the possibility to manage the feelings. So one of the things that we do all the time in clinic is to talk about how the law makes you feel. And in that way, we start to identify the frustration, the reasons behind the frustration, and talk about, okay, but this is not your life. You could be in the possibility to do it again in another scenario. You have to separate the expectations of the success of your work from the knowledge on the learning that you have had and that probably could be useful in another scenario. And in addition, we always talk to students that they have to be patient. And in Peruvian case, at least, that is not only patient for legislative process, but also for litigation, because judicial process in Peru take so much time. So it is important to be patient and to understand that this process take years sometimes, months, years sometimes. And another thing that I think is it's very important um, is that we teach them that if you are not in the same page with a civil society organization, that is okay. You don't have to take it personal, but also you don't have to quit your personal ethics too, because sometimes the organizations could ask something that it is not illegal, but it's not part of your ethical framework as lawyer. And it is important to say it loud too and to reflect about that. And I am now remembering that some years ago we had this discussion, legal discussion, because the Congress was working on a personal assistant legislation for persons with disabilities. And there was two clear groups in this process, because on one hand we had the person with disability that needed the human assistance, but on the other hand was the assistant personnel. And at some points, these persons that dedicate their time as personal assistant wanted the same benefits that persons with disability, wanted to be treated by law as persons with disability and obtain the same benefits, financial, taxes, and everything like that. And when we discussed with the students the proposal, they said that I am not in the same page. I don't feel comfortable uh, giving this group of persons that, of course, they perform a very value work, but I don't feel that they are persons with disability and they have the same structural problems that persons with disabilities. And they were like, I don't know how to proceed now, because I'm supposed to work with this coalition too, but I don't feel comfortable doing that. So I think there is a very, very delicate balance between don't take it personal, don't push for a specific solution, but also don't quit your ethical values.
Oh, thank you so much. And
Sorry.
no, I was muted. We have a couple minutes left here. I want to make space for questions from the audience as well. So you can either raise your hand and we'll call on you to come off camera and ask your question live, or please feel free to put your question in the chat and we can read it out loud to our panelists to have them answer as a group. Janelle, I see your hand up. Can you go ahead and come off mute and on camera?
Absolutely. I just wanted to say how much I enjoyed both of these presentations and how much I appreciate your work in this space. It occurred to me while Renata in particular was talking about the law reform being done through legislation, it occurred to me that one important distinction here is between a sort of civil code-based legal system and the common law system that those of us in the United States find ourselves working in. So that law reform clinics are often litigation clinics because you can change the law by filing lawsuits that result in a change in law as opposed to just helping an individual. Whereas in a civil system, you've got to change the law by going through the legislative route. And I just wondered if that's something that resonates with you.
Yes, absolutely. Thank you for the comment. Actually, we changed our civil code in 2018, but from 2013, a specific constitutional judge, a specific family judge in Peru started to unapply guardianship and to appoint some support for persons with disabilities and safeguard without any kind of legislation. It was just heroic creation from the judge. And for us, it was very it was very difficult to take a position about that because not only because we need a law as a continental from a continental perspective of the law, but also because it's very dangerous for us giving so much power to a judge because the preparation and the perspective of the judge work in our legislation, I think is not the same that yours. In your judicial system, the judge knows that he is in the possibility to issue some rule and are trained for that. They are trained for that. But in our context, that is not a possibility. So even though I think this judge was very well intentioned, I think that he didn't measure the possible impacts that an judgment like that could create. So that is something that a discussion that we had all the time since 2012 until the reform, that if we should pressure the judiciary to and apply guardianship and to rule from a point by a specific judgment, or we should wait for the modification of our civil code in order to work on a very, very consensus basis.
Yeah, maybe very, very quickly, just to say that that of course, as you said, it is has to do a lot of with the context of every country, and in our case, we have a lot of work through strategic litigation, trying to have these important cases in our constitutional court. But in some scenarios, then we said it will never be enough. You have to have like 1 million cases to do it. So in terms of, for example, in our experience of legal capacity, we generate a very important strategic alliance with the inclusion office of presidency at that moment that help us with all the political move to create a caucus in disability within the Congress that will help us later to pass the legal reform that we will also be helping with our students, with organizations to push it. And in some cases, as it said, it is very difficult to have the law. So we also try to have these strategic litigations in our constitutional court that will eventually have the results of regulating for example, by ministry. One very important case that also is very recently is that with the pandemic, we have the situation that happens in a lot of countries in the world that people with disabilities and elderly people will not have the urgent attention in the health system because they do not have enough resources and they have to do trudge decisions, and always the people with disability and elderly people will lose against a person that is normally functioning and will have more potential if they recovered. So we litigate a case that went to the Constitutional Court, and our objective was not just to protect the lives of the people that we were representing, but also is to enable the judges to see that we did not have any kind of regulation, and the Ministry of Health will have to make that regulation. So then we begin our implementation of the ruling is to have a regulation that came out at the beginning of this year. So that we can have now a mandatory thing around every hospital clinic in Colombia to say you do not you cannot be able to discriminate for disability when you have a situation of scarce resources in the health system. That is very, very important. So yeah, that's another scenario.
Thank you both. We are coming up on time, but we have one other question in the chat I want to make sure we get to from Professor Kutsianaki, who's one of my colleagues here at UDC Law. And she asks, the history of and literature around social movements has shown that their success is predicated upon conflict and contestation that results in social and legal change. So you spoke about the conflicts that might arise within coalitions, but what types of conflict and contestation have you experienced outside of those coalitions from opponents or from detractors who did not want to see an expansion of legal capacity for disabled people? And could you discuss any of the tools and strategies that you and your student used to address, especially the narrative around legal personhood and agency for people with disabilities?
Maybe very quickly. It's I think that we have two scenarios here in Colombia within that context. The first one was that the guardianship was a very common cultural regulation. Is that every family that have a person with disability eventually will have to be under guardianship. So the first thing that we have to do is like to show that this was more a cultural than a legal necessity, because every health provider service in Colombia was saying you have to have the guardianship in order to have these rights. So the first thing is legally, there's nothing that you have to do with a guardianship. And the second thing that was more like a practical scenario about how legally the guardianship was working. And the second one was that culturally there was also the idea that the guardianship will protect the person with disability. Eh, for example, if they committed a crime that has nothing to do with the guardianship, that there was a very important myth here around the guardianship and the criminality of persons with disability. And the other thing is that they'll feel that if they have the guardianship they will be more protected because they have a person that is more involved in the life and making the decisions for the person. And what we tried to adjust in terms of that narrative was to show that um, maybe you could have a little more protection, but that's not a real protection, because the person eventually will be without the persons that are around. So you have to build a lot of skills, capabilities, capacities for the person to live autonomously, to make even the small decisions, and that also that the legal system have a lot of things to protect, for example, in terms of economic health situations that does not have to do with taking out the possibility to decide for the person. And we did this also a lot in terms of um, education within mass media. We have commercials on TV, we have commercials on radio, a lot of things that people had never heard that part of the story. So the Ministry of Justice, a lot of other ministries were very involved, and especially faculties of law, doing a lot of workshops in the streets with the families, with the persons, to showing this scenario. Ren, microphone.
Sorry.
Yeah.
I completely agree, and I think that we are kind of in the same page with what Federico said. I will only add one thing, that is that we in Peru we had a lot of. I wouldn't say that we are in a non-conflict context right now, even though the reform was approved in 2018. We still have a lot of opposition against the reform, and this opposition came from families in time, from notaries, and from civil law professors. So for us, one of the strategies has been to try to identify some allies in those groups. Families is more or less simple, but in notaries, we are now trying to create a network, a notary network for legal capacity. And in the case of civil law professors, we are also trying to, well, actually, we have now a working group in the university with civil law professors trying to respond and to identify and solve some of the critics that could another professor have against the reform. And I think that it's important in these scenarios to try to identify one or two allies in each opposite group in order to start the conversation. Because of course, I accept that the reforms could be modified and could be improved, and maybe we made mistakes when we approved that, but that not invalidates the whole reform. So I would say that our strategy has been trying to create these dialogue groups And also, we have a very good relation with our National Council on Disabilities. And the National Council of Disability, that is the public entity in charge of disability politics, is also very close to our work. So we have a lot of seminars and, in general, dissemination information with that.
Thank you both so much. And thank you to our audience for engaging deeply with these questions. I'm really grateful. I've learned so much from the two of you in prep and in this conversation. And I'm really grateful that we got to welcome more people into that conversation today. So thank you both. Today's conversation was recorded and it will be available on our website and our UDC Law YouTube page, along with previous conversations. So I hope you all get to check those out when you have a moment as well. And have a great afternoon, everybody. We'll see you soon.